Well, welcome everybody. My name is Dave Cohen. I'm a director here at Mina Partners. Mina Partners provides advisory and operational privacy program services across the privacy and IT security landscapes. It's my pleasure to be hosting a short discussion for you all today. I appreciate everyone joining us. We're going to be talking about the major state and federal privacy law developments and enforcement actions as we are here in April. All of a sudden in 2026, the year seems to be moving rather quickly. And to discuss these developments and kind of things that you might pay attention to from a practical standpoint, I've got two great attorneys from Womble Bond Dixon, and Tara Cho is a partner with the firm and works out of the floor of the office in Florida. And Tara, can you tell us a little bit about the practice and your kind of areas of expertise?
Yes, and correction, I'm not quite that far south. I'm in our Raleigh, North Carolina office.
Oh, that's right. Pardon me. Yeah.
Happy to be here today, and really glad to have Tyler join us, and I'll let him introduce himself. But we're both part of the privacy and cybersecurity team at Womble and cover all of the U.S. state and federal laws, as well as GDPR and UK GDPR and beyond. And we're also part of the firm's newer formalized digital solutions group, which covers everything digital data related, from AI and privacy to IP and beyond. So thanks for having me.
Thank you, Tara. Welcome. It's great to have you on the program. And Tyler, I know you just got back from a trip over to London. Welcome back stateside. And can you tell us a little bit about your practice and your background?
Yeah. Well, turns out I was speaking at the U.S. Embassy in London last week, and UK industry is very focused on GDPR and privacy compliance. So it's very top of mind there. They're pretty nervous about their regulators. It was interesting to hear about. But my name is Tyler Brady, and I am also a part of the Womble's privacy team. I'm located in Houston. Prior to joining Womble, I was the director of privacy and tech enforcement for the Texas Attorney General's office, where I was sort of in charge of implementing all of the brand new shiny Texas privacy and tech-related laws that were being passed in pretty rapid succession and over the past 4 or so years.
Terrific. Welcome, Tyler, and thanks for making a little time for us for this conversation today. So let's dive right in. And Tara, I think I'll start with you. And we did title this conversation as kind of state and federal privacy law developments. 2026 so far. Little did we know, I think, that just literally, I believe yesterday, a new federal privacy bill dropped, and you've had a chance to kind of get in there and look at that. So I wonder if you'd share with us what that looks like, and maybe talk a little bit about how it might differ from previous bills that have been introduced.
Yeah, well, I'm sure for those in the audience, they're used to having federal bills put forth and having a lot of division around state law preemption and private right of action, and not gaining a whole lot of traction. The bill that was dropped yesterday is a Republican-backed bill that is very much, in my view, aligned with a lot of the existing state law principles. There's no private right of action. It puts enforcement authority with the FTC, and without getting into all the details of it, I just think in concept, the principles are more clearly aligned in a way that would be an easier transition for companies to address the federal standard. And while there is preemption addressed, like I said, the private right of action is not presented, and the principles cover transparency, consent, notice. There is an emphasis around sensitive personal information. And it just seems like something that might be palatable to gain more traction, perhaps, than what we have seen in the past.
Yeah, I think
go ahead, Tyler.
I don't think there was any surprises in there necessarily. Like, it's not going to be a full GDPR opt-in style, but it's also not, it's in between the GDPR on one side of the spectrum and California sort of being the opt-out model on the other side of the spectrum, and it's in between, which is, most states at this point. In the private right of action, HIPAA, I always look at HIPAA as sort of the baseline for what a federal privacy law might ultimately look like, and there's no private right of action in HIPAA. So the state AGs are required to notify HHS before filing a suit pursuant to HIPAA. So all of those provisions are very consistent with sort of the federal law, privacy and data related laws that are already on the books.
Yeah, so perhaps kind of a nice balance, as you state, between providing the consumer protections, which are now, pretty prevalent through almost half of the, U.S. states, but along with some harmonization and a bit more business-friendly requirements that would kind of ease the burden for companies trying to comply with this, and regardless of jurisdiction from a state perspective, it sounds like. So perhaps a little bit of a more possibility of it moving forward than previous iterations, which we all know there have been many of them over the previous years.
Yeah, and I would say somewhat of an emphasis there too on commerce and enabling digitization, again, in a way that is proactive compliance steps rather than reactionary, like the original data breach laws that were more so what happens if you lose the data. And it seems like state breach laws also would not be preempted. Those would still remain in effect, as that's not covered.
Yeah. So to that effect, that's probably a nice segue, Tara. Tyler, I'm curious to hear from you, based on your previous experience working in the Texas AG's office. As you look at from January 1st, 2026 to today, how have things changed in terms of the AG's offices across the country in terms of what they're looking for compliance with regard to all the state laws, just kind of in general? Can you just kind of characterize any themes that you think the AG's offices are more focused on now than they might have been in 2025?
Yeah, I think, it's sort of from the government side, people, I think a lot of in the different state AGs and regulators hear this critique. The private sector seems, and even some of the nonprofit sectors, like clamoring for a ton of enforcement to come out at all times. But that's not real. That's just not how it works from the government side. And part of that is, all these state AG offices around the country, for the most part, do not have any expertise in privacy, right? And so these privacy laws are brand new to them. A lot of them have cyber breach reporting laws, but those are often done by multi-state. There might be like one person in an AG's office who is sort of in charge of monitoring what's going on in that arena, but not really like in-depth expertise, and it's just a piece of their sort of portfolio. So there's an immense amount of learning that sort of has to happen on the inside of these different AG's offices before like they can even sort of wade into any sort of public enforcement matters. And so, what that's going to look like is, one, understanding the laws. Two, as a government, you're doing investigations. So not only do you have to sort of have a substantive understanding of the laws, you have to know how to dig and know what to ask about, look for, and what sort of conduct to target. And so, I think a lot of California was obviously the first law to take effect. So, they had a bit of a head start on all the other states. So that's, why you've seen the most enforcement publicly from them. Sort of the second tranche of states that have been doing, whose laws came into effect: Connecticut, Oregon, Texas, Utah. You've seen sort of statements and some enforcement actions out of them, but expect those states to keep sort of learning and figuring out what conduct to target and how to conduct investigations. And then there's several states that have come online recently that are maybe not privacy experts necessarily, but they're like known for being very sophisticated offices and well-resourced and good attorneys. So that's Indiana, Minnesota, New Jersey. Like those are three within the sort of AG world, very formidable offices. And so those three all have their privacy laws to enforce. So I'm kind of looking to see what actions they'll do. In the first tranche of states, there's a big focus on, in part because of public, the public news cycle, but on geolocation data, particularly with respect to vehicles. There's been some quite a bit of like publicly announced enforcement actions. Several states filed lawsuits over that. Montana last week announced 2 more investigations into which Montana also has a privacy law that people might forget about sometimes. But Montana announced 2 investigations into car manufacturers last week. So that geolocation data in those practices are still very much sort of percolating, and at some point you'll see, I expect before the end of the year, quite a few settlements related to geolocation data. I think a lot of AG's offices have sort of behind the scenes spun up children's privacy and online safety related investigations, and sort of figuring out more what's going on there. A lot of states have new-ish social media children's privacy related laws, and so there's, similar to comprehensive privacy laws, you're learning this new law, figuring out sort of where the strengths and weaknesses of the law are when it comes to enforcing it. You're also having, in certain states' cases, figure out how those laws are interplaying together when doing investigations, and trying to build a case as to why a company is engaged in violations. But I very much expect children's privacy and online safety to be a continued theme. And then healthcare adjacent data is, I would say, another big area. There's Washington My Health My Data Act, which has a private right of action. So there's sort of some burden alleviated from it just being, the Washington AG's office enforcing it. But I think that's a data type that is extremely interesting to regulators. And you'll notice the common theme from all of those data types we've discussed. They're all considered sensitive data for the most part under state privacy laws. So it'll be, sensitive data continues to be, I think, probably for the next 5 to 10 years, where regulators will be paying a lot of attention.
Okay, so for those of you on the call that are privacy enforcing or developing privacy programs at your companies, big takeaway from that is pay attention to sensitive personal information that you might be collecting and processing, including geolocation, children's data, biometric data, increasingly biometric data, as well as others. And Tara, you were going to say something?
Yeah, I guess just to build off of that, Dave, having seen sort of the trajectory of before any of these U.S. laws existed, and the main concern was GDPR to where we are now, I think particularly if you start with states like California that have loads of resources and subject matter experts, dedicated bodies that started with the first law, they're seem to be less looking at, did you do XYZ as stated in the reg, but is it actually operationally appropriate, and looking for things like dark patterns and actually having the software and tools to evaluate whether your GPC is working and that you're effectuating what it says on your website. So it's gone, I think, a step further to not just the low-hanging fruit, but more technical evaluation of is it seamless? Is it as easy to opt out as it is to opt in, and things of that nature, which I think is going to give rise to the other things that are coming, such as in California, like ongoing audit requirements and risk assessments and the like, which to borrow what Tyler said, and anybody who knows me knows I really love HIPAA, because I think it is stood the test of time, even with all of the evolving technology, as a good framework. But that is something that is pervasive there too, to constantly evaluate what type of data you have and what type of technology, and is it being effective. And so I think that's going to continue to be a big requirement, and you see the laws sort of coming behind and mandating some of it. Like for those of us who've been doing it a long time, know that data inventory is like step one to know your data. Where is it? Where's the sensitive data? Where's the high risk stuff? And now having like models that actually say you must do this, you must update it. It should lend itself, I think, to a smooth transition for those who had been doing that type of framework overall, rather than trying to adjust every time a new state comes out, to join.
Yeah, so no, that makes a lot of sense, Tara, and I think so a big kind of summary takeaway there is if in previously, and again for those of us that have been in the field for a long time, at some point it was like, well, if you have a good notice up and maybe you have some internal documentation around policy and you say that you've got a privacy program, that used to maybe pass muster. That does not pass muster any longer. These days you need to not only have that, but that has to align with the actual operations, and the actual operations have to actually work. So if to put everybody on notice, it's, and you referenced dark patterns. I wanted to provide a definition for that for those of you in the audience who aren't familiar with the term. I've always been kind of fascinated by this. It refers to your user interface on your website and whether you're kind of consciously or unconsciously steering the consumer, the user of the website, to one choice over another, i.e. have a big blue button that's very prevalent and then a small light text down below for another option that you don't prefer the user to take. That's a dark pattern, and it's obviously available to the public. Regulators are scanning websites, they're flagging these kinds of things, and that's what's going to put you in the radar of the regulators, as well as as you mentioned also, I think, Tara, the GPC, or the Global Privacy Control Signal, that comes from browsers when folks visit your company's website. It's not okay to just validate that you've received that signal. That signal actually has to work. So all of the mechanics behind the scenes about honoring that signal and truly opting that visitor out from dropping cookies and opting out of sale, et cetera, need to flow downstream, and they need to be operational. And as you mentioned, Tara, a big place, and maybe Tyler, you can talk a little bit about this. The downstream third-party vendors is a place where continuously companies struggle with this. We know this from our work with MINA. It's a lot of the focus of our work is trying to get the internal house in order in terms of data inventories, data mapping, and understanding third-party vendors, what they're doing with the data, whether contracts are in place that are up to snuff with regards to data processing. Tyler, can you comment on that piece a little bit?
Oh yeah, this is my favorite thing to talk about, Dave. So thank you. I think this is not necessarily a blind spot, but a very easy area to target for regulators. And I know for certain that they're targeting this more. So all your vendor agreements, third-party agreements, those have specific contractual mechanisms, provisions on how data is handled, sort of what rights there are to the data, the use cases that the third party can use the data for. It is the easiest thing in the world for a regulator to subpoena those, and they have increasingly been. And step one, the first thing they're looking at is, when was it last updated? If it was signed, and hasn't been amended since before that state's privacy law took effect, there's going to be questions instantly about it. The other aspect is those use cases in those agreements are very detailed, and oftentimes, and regulators are looking at those to see, is this a service provider agreement, or are some of those use cases falling outside of what would count as strictly providing a service to the company, and are they giving basically rights to to use the data to that third party? And if so, that there's a range of implications at that point. If it's sensitive data, that would mean that with the exclusion of California, which has a opt out regime for sensitive data, but for all the other states, you're generally required to get explicit informed consent before processing any sensitive data. And so if you've granted a third party sort of their own use cases or ability to use that data how they want to, that sensitive data, and didn't obtain the appropriate consents on the front end, that's really hard to walk back. And you're also going to want to make sure there's, because of that, deletion mechanisms within those agreements. And so those are really, sort of step one is making sure those agreements really not just comply with the law, but also provide mechanisms to, if there's regulatory scrutiny, or if a law's changed and there's suddenly like some of these provisions are no longer compliant, like an ability to get data back or get it deleted in some way, I think is increasingly important. Because even in cure periods, if I sold Terra, but I didn't have the appropriate consent to do that, even if I have a 30, 45-day cure period, I sold it to her. She owns it. How am I going to get it back? I knew everything on the front end. And so you're really, and that's hard to execute on within, a 30-day cure period. Like getting a counterparty to a sale to agree to something, not easy in a short period of time. But, so I think keeping those agreements up to date is step one, and updating old ones, extremely important. And then, like you said, Dave, be tracking what in fact they are doing with the data, or at least making sure it's clear from the contract what you expect them to be doing. But I think there also need to be audit mechanisms, or to the extent there aren't some form of audit mechanisms in that agreement, where you can pressure test that they are in fact doing what they said they would do with your company's data. Those need to be in there. And I think regulators will increasingly push and inquire on send inquiries to companies, figuring out how often they are in fact using those audit mechanisms. Because if it's in there and it's never used, it's hard to credit a company for just including a provision that they never used in their agreement.
Yeah, that makes sense. Staying with the third-party vendors topic for a minute, Tara, one of the things that we discussed prior to the webinar here was a requirement in some of the state laws that are now in force for listing third-party vendors. Can you talk a little bit about kind of maybe some recommended best practices there, understanding that it depends on the situation? But I'm curious as to whether those listings can be by category, or do they need to be company name? And is that dynamic or static? And if it's static, we know that vendors change all the time. How are companies expected to keep up with keeping that list fresh and up to date?
That's a good question, but I think everything that Tyler just described is also just part of having accountability and governance, regardless of the size of your organization. If you have particularly outbound data to a third party, whether it's digital through pixels or data co-ops or otherwise, you have to know and understand those relationships and be accountable for them. So a couple of the states, it would be more providing on request the categories of third parties with whom you share the information, not dissimilar from California, but presenting that list on request. Some give an either or, the categories or the list of actual third parties if you know it for that person. It's hard to know individually that I shared Tyler's specific information with these 4 entities versus 20. But then Rhode Island goes a step further in requiring the affirmative posting of the actual third parties, which is a little similar to GDPR subcontractor list. And so that's something that, a lot of clients are not in favor of, to have that publicly noted. To be honest, and Tyler might have thoughts on this, I suspect, some vendors, for instance, like to have in the contract the right to use your logo to say that you're their customer. A lot of plaintiffs law firms will go to those sites and look at who's using this product, and then use that as their target list of who to file certain types of claims against. In the land of SIPA demands, which I won't get into, that could be problematic. But nonetheless, it is a labor to maintain a current list, but that is like an affirmative action required under Rhode Island to have that linked and posted. And so one way to do it, it might be to describe that list for Rhode Island purposes, and then another way would be for the other states that require you to share that is on request and sending that link to those individuals, as requested. I think the other interesting fact, again, not to go down a huge rabbit hole, but the accountability with third parties that Tyler was mentioning is really critical. And I think there's been a historic, as you would expect, sort of leaning on the fact that a lot of these things are click-wrap terms and not negotiable. So trying to get in the nitty-gritty or even negotiate service provider language versus third party has been a real challenge. But now it's being examined even further by organizations when you get into AI concepts and what are they doing with my data, where are they putting it? And so there's just across the board accountability that I don't think vendors are necessarily, depending on how big they are, how much leverage there is, going to continue being able to say it's non-negotiable, because they won't be able to use them if they can't identify some of these points.
Yeah. Are you trying to say that AWS won't get on the phone with you for an hour and, responds to all of your particular requests?
No comment. But, as we all know, there are a lot of non-negotiable click-wrap terms that then have multiple link outs, but most of the organizations do account for these shifts in law and put the onus on the user. Like, if you haven't signed up for this offering of ours that has a business associate tied to it, you don't put PHI in here. That's not on us. And so I think that's also a thing for organizations to consider. If you don't know whether they're collecting sensitive information or using and selling it, then you have to put it on your business clients internally not to put certain data within the platform or use it for certain purposes.
Right. Yeah. And speaking, you mentioned Rhode Island, and that made me think. I was doing some review of the particular requirements for the state laws that have gone into force this year. And for a relatively small state, it's worth paying attention to the requirements in Rhode Island. They differ from, whilst there are some similarities, they differ from some of the other state laws. There's a lower threshold and a $10,000 per violation penalty. So not nothing. And it wouldn't be surprising if you're doing business domestically in the United States to not have some customers from these states. So while there are some similarities, and you can build out your privacy program and your responses to these consumer requests, rights requests that can be handled kind of in a group way, it is important to pay attention to some of the differences, right?
Yes, definitely. But I think following those principles that we've been talking about will make you more agile to adapt to whatever tweaks one state might have over another. It's really about accountability and building the foundational governance, and in my view, which is easier said than done, but it makes you more poised for whatever happens tomorrow.
Absolutely. Building your privacy program on those principles, having accountability, building out a good governance program, having a base, and then being able to customize individually where you need to. Yeah, that makes a lot of sense.
And I think,
go ahead, Tyler.
I was going to say, like, on the back end of that, though, is at the end of the day, these are regulatory, you're compliant, trying to demonstrate compliance, or you're going to have to potentially demonstrate compliance with a regulatory regime to a third-party regulator who does not know your industry necessarily, does not know your practices. And so it's sort of important to keep in mind, like, you also need to be like building an internal narrative of what all the steps that you're taking. So just not just accountability, but being able to demonstrate that accountability, and sort of have that story to tell should the government ever come knocking.
Yeah, I was reviewing the California's assessment requirements for high risk processing activities. And when you read about that, it's pretty clear that, and the state of California, to the best of my knowledge, hasn't provided any templates or kind of standard format guidance. And I think consciously, because to your point, Tyler, it's they don't want it to be a checklist exercise. They want you to be examining your data use processes internally and be able to have some rationale for the potential harms that can exist with those data uses, and the remediations that you've come up with, the protections that you've put in place, the alternatives you've looked at. So again, it really is analyzing and being able to tell that story through documentation and having that in place before, not after being noticed, and having some attention from regulators. I want to move over to, we did receive a question from the audience. This is an interesting question. I wonder if either of you have some thoughts on this. It seems some industries are less scrutinized than others. What industry do you think is next to be the focus point where the government will be looking to examine data use processes? Do either of you have any thoughts on particular industry sectors that are being looked at more by the regulators than others, or just across the board?
Tara, you want to go first?
No. I know you have strong thoughts.
I do. So it's always difficult to predict, but I don't think in 2023 anyone would have thought the car manufacturing industry's data collection practices were going to be sort of the target area. I think for the most part, it's oftentimes more practice specific as opposed to industry specific. So, I think be prepared for companies that are using data for algorithmic pricing. I think that's going to be a big, the FTC, state regulators, I think they will be looking for a way to bring a big splashy enforcement action in that over the next, before the end of the year. There'll be something on that front. The FTC has taken a really, and this isn't necessarily strictly data specific, although there's a lot of data elements to it. The FTC has taken a very active, I would say, sector specific approach to their enforcement activity. So, over the past year, we've seen the FTC announcing a big settlement with one member of an industry. So, most recently was, or there's been a few, but one, for example, was rental management software company, who is basically in charge of creating like the consumer interface for pricing of rental buildings, apartments. Sorry, God. But they hit one with a big enforcement action, and then they send warning letters to the rest of the industry. And so generally, that's saying like, we are pretty sure you engage in this activity. We created precedent with this one company, and we expect your practices to come in line accordingly. We'll see how state regulators deal with that. I think they're still cleaning up a lot of the car manufacturer investigations. I think insurance is going to be, the insurance industry consumes a lot of data. I think that is one to expect regulators to figure out ways to dedicate more resources to, and figure out sort of how to rein that industry in overall. I think, a closely related, or insurers largely rely on the sort of broader data broker industry. And so, I think that's another sector where there's going to be a lot of attention going forward. I think advertising is kind of, in some ways, targeted advertising is not companies doing a lot of advertising using data for advertising. I think that's sort of, I think focus is sort of coming off of those practices, but with the exception of if you're doing targeted advertising based on sort of like, or with an algorithmic pricing.
Algorithmic, yeah. So AI governance being the theme of the day, and understanding what AI tools are being used within your company, documenting them, providing some transparency, analyzing and prioritizing risks and addressing them internally. That makes a lot of sense. Not just quickly, Tyler, while you were talking about that, it brought to mind something that we also discussed in preparation for this conversation, which is that earlier this year, it was announced that there are some multi-state AG office actions taking place. And as most of us know, the Attorney General's offices are in good communication with each other regularly. Do you want to talk a little bit about that? And then maybe also talk about what it looks like if a letter is received, and what some of the first steps might be for a company who is undergoing some regulatory scrutiny from the AG's offices.
Yeah. So there's been, historically, there's been a privacy in cyber working group across the AG's offices where, it's basically, every AG's office is invited. There'll usually be a point person from each office. Not all, and it's just a way to sort of formally touch base every month and discuss who's focused on what. If there was something, say a big data breach that several states are interested in conducting an investigation into and potentially escalating to an enforcement action. It's a way for them to sort of pull which other states might want to dedicate resources and it's sort of work together to go after a company in sort of the multi-state scenario. And to take a step back, it's gotten a little messier as only historically all 50 states have a breach notification law. Only a chunk of those have a privacy law, so we'll still see how an actual multi-state privacy law specific matter is able to press forward, because there's just not one-to-one legal authority across the different states at this point. So we'll see how they can that actually plays out in the privacy law specific context. But so there's sort of a subgroup of states with privacy laws that are working together, sort of more, I would say, that harkening back to what I opened with. They're sharing resources on sort of how to interpret their privacy laws and sort of what conduct to be on the lookout for. And so that's sort of the privacy laws are very much, states are still getting up to speed on that. The third mechanism is, or the third, I would say, collaborative body is the, what is it called? The one that was announced last year, Consortium of Privacy Regulators, which I think has about 10 members. And that was, pushed by the California Privacy Agency, in part because they're not part of the AG world and do not have as broad legal authority as AG's offices. So that was sort of a way for them to sort of collaborate more with other state AG's offices. Sort of to your question on what it looks like, whenever not every matter is not every company is necessarily subject to a multi-state matter. Oftentimes there might be one state probing, there might be a second. If you're the company and the lawyers representing the company, at some point you sort of have to decide whether you want to start pushing the AG's offices to form a multi-state, because what's happening on the company side is you're getting all of these different subpoenas and questions from different AG's offices who aren't necessarily coordinating. So it becomes a pretty heavy burden to produce all these documents and sort of advocate in front of a bunch of different AG's offices. If a multi-state is formed, they generally will send an identical or nearly identical set of requests to the company. And so there's a way to sort of, I think there's some efficiency there. There's obviously a bit more risk potentially because there's so many states with authority looking into you simultaneously, and that's a calculation that companies have to make. But generally, anytime it's over 10 states, it's probably good to push for a multi-state. That's going to get exhausting very quickly.
Yeah, and to state the obvious, work with counsel on this. Yeah. And also pretty important to note that several of the state laws that went into force in 2026 have 30-day cure periods where there's an opportunity and a window for remediation there, but also some cure periods have expired. So Tara, I'm sure you work with clients on that too, trying to figure out best strategies moving forward. Yeah.
I actually had a question for Tyler on that, and no, I'm not trying to place judgment, but again, analogizing to HIPAA, I generally assume when I'm reading like a settlement agreement that ends in a resolution and a settlement amount versus a CMP, there's collaboration and coordination with the agency to reach that resolution. Whereas the CMP, sometimes it sounds like really extreme conduct, and I'm assuming not cooperation. Is the same true for state AG investigations and enforcement? Do you think, Tyler, if you're allowed to speak on it, that when you see these huge numbers in some of the early cases in particular, some of it seemed like low-hanging fruit that maybe you could have tried to clean up or do something? Is there a sense that maybe the company didn't cooperate or tried to argue the position? Or
Yeah, I mean, I think we saw the Cal Privacy filed a petition to compel against a company at the beginning of this year, which investigations are generally done in the background. There's some states that are much more public about when they're investigating someone, but on average, states generally keep that confidential. And so, having to go to court to compel production in a previously confidential investigation is a pretty extraordinary step from the government. The government does not want to dedicate that level of resources to discovery about something that, like, under the law, you're required to respond anyways. So they're going to win in court whenever that happens, absent the request being truly untethered to what the investigation is supposed to be about. I think there's also there's a lot of communications that are, whenever these investigations are happening, there's a lot of communications going on with counsel and separate communications happening with counsel for the company, and regulators check with each other to make sure like they're being told the same thing by counsel, and when they're not, or like certain things were produced to one state and not another, like there's a very big risk that a certain AG's office will be unhappy. At the end of the day, like, you do not know what the government knows. And so oftentimes before you ever hear from the government, they've done like a whole or pretty extensive investigation. If it's like a bigger target or like a big company that they think might not necessarily be cooperative, or they know is going to fight, rightfully so, or within their rights, fight every step along an investigation. Oftentimes, like, regulators will go to third parties first and get sort of the story and copies of the agreements, figure out the data flows and what actual practices are happening behind the scenes before ever contacting the actual target of their investigation. So oftentimes, we would spend the first 3-4 months of an open investigation never interacting or even letting the actual target knowing that we were subpoenaing documents from parties that we knew that they had a relationship with. So they're just, at the end of the day, your regulators are looking to build a case, in a strong case, and so they'll sort of look for things that help them do that. And that might be low-hanging fruit. Talked about the date of vendor agreements. If your privacy policy hasn't been updated in years, that's a pretty easy tell for a regulator that not only is your privacy policy probably out of date, but your other practices probably aren't as strong either. And so there's sort of that, you want to avoid the low-hanging fruit, especially when there's so many regulators sort of looking at compliance with these privacy laws.
Yeah, so just to be specific about that with regards to that low-hanging fruit mention, make sure that your privacy notices are up to date and have a fresh up to date and are regularly reviewed. And by the way, nomenclature wise, the difference between notices and policies is often debated in the privacy world. Notices are your public facing website declarations of your data uses. Policies more typically refer to inside policies about how that data is to be used, that then operations and governance strategies can be in line with those policies. But also important to mention that regulators these days have access to all of the same technology tools that companies are using, hopefully, to be able to monitor their data use practices and their consent management practices. So be aware that AG's offices are technically competent and have technical folks who are doing scans and are looking. So anything that's publicly facing is a good place to start in terms of prioritization for your compliance actions for your program. So we're 45 minutes in here. I want to be respectful to your time. I know you both have busy days. Any kind of final thoughts or closing statements while we also wait to see if anybody has any last minute questions?
I would just say investment in proactive governance is well worth it, rather than waiting until you have an issue or to Tyler's point earlier, you need to prepare a background narrative to tell a regulator how you landed in this spot. So along the way, those decisions are important if you have to think about the story you're going to be telling if under the microscope.
Yeah, I think that's exactly right. Like, it's a combination of avoiding low-hanging fruit, or like obvious external signs of non-compliance, and then understanding that your regulators aren't necessarily looking for perfect compliance, but they are looking, if you're contacted by a regulator, they are looking that you're doing something on that front, and not just sort of, not able to communicate what you've done to comply with the law. But also keep in mind, like, regulators are probing 50 plus companies at the same time. And, they're not just looking for low-hanging fruit signs of non-compliance, they're also looking to go after sort of the worst actor in that group of companies. If you're able to quickly remedy like anything that they saw and show general, like, sort of good faith efforts to comply with the privacy law, the regulator is happy to move on. So just keep in mind, like, your compliance program is not in a silo.
Yeah, terrific. Well, Tyler and Tara, thank you both so much for providing some time for us today. Great conversation. For those of you out in the audience, I hope we provided some good practical advice and some takeaways. We've put up our contact information there for all three of us. Please get in touch if we can help with any legal guidance and or operational privacy program strategy advice and configurations. So thank you both again one last time for being with us today. Thanks all of you for joining us. And with that, I'll go ahead and take us to a program close.
Thank you.
Thanks, guys.